members, Counselor Joe Horn. So I am calling this meeting to order by going through the formal process. This is Ronald Crutcher. I can hear everyone, and I will go now to Mr. Hughes.
Josh Hughes, I'm able to hear everyone.
Mr. Schultz.
This is Kenneth. I'm able to hear it.
All right. Lee.
This is John Lee. Had a little, Kenneth was broken up a little bit, but I can hear everybody sort of.
Okay.
Is that a little clearer, John?
Yes.
Okay, thank you.
All right, Mr. Adams.
It's Glenn Adams, and I can hear everyone.
All right. We have a full, as I said, we have a full membership of the committee. I will start the meeting by pointing out that we have the minutes from the previous meeting.
Mr. Chairman,
Go ahead, Mr. Cook.
I need to read the statement before we proceed.
Okay.
If there is no objection from the Board of Adjustment and Appeal members, and subject to Executive Order number 78, let the minutes reflect that the members have determined that it is necessary that this meeting be held electronically to protect the health, safety, and welfare of the public due to the COVID-19 pandemic. Are there any objections? Let the minutes reflect that the board has made the determination to conduct this meeting electronically. I do want to remind everyone that each vote must be taken by roll call vote. The chairman will call the names, at which time you will provide your vote. Prior to making a motion or second or asking a question or making a comment, please identify yourself. Mr. Chairman.
First order of business is to review, comment, and approve the minutes from the previous meeting. Are there any questions, comments on the minutes that were sent out with the agenda? All right. Hearing none, I will entertain a motion to on the minutes of the March 11th meeting. Do I hear one?
Mr. Chairman, this is Kenneth Choate. I make a recommendation. We approve the minutes of the last meeting.
Mr.
Do I hear
Chairman, this is John Lee. I second that motion.
Motion's been properly made and seconded. Are there any other comments? Hearing none, we will do a roll call vote. I will begin as Ronald Crutcher, chairman, and I vote to approve the minutes. Mr. Schultz.
This is Kenneth Choate. I vote to approve the minutes of the last meeting.
Mr. Hughes.
This is Josh Hughes. I vote to approve the minutes.
Mr. Lee.
This is John Lee. I vote to approve the minutes.
Mr. Adams.
It's Glenn Adams, and I vote to approve the minutes.
Minutes have been approved. We will move into the new business, and I will turn the meeting over to Mr. Cook to lead us through that and give the staff positions.
Thank you, Mr. Chairman. I'd like the record reflect that adequate public notice is given to both the home builders and to the public. The first appeal before you today is from Aspen Construction, and without objection will be heard as a whole because the basis for each appeal are the exact same basis. Let the minutes reflect that no additional documentation or explanation was submitted by Aspen Construction. The first argument the appellants make is that they have obtained vested rights under the Vested Property Rights Act of 2014. So the lots at issue would not be subject to the impact fee. The Vested Property Rights Act provides that should a developer receive preliminary plat approval from the local authority, development standards in place shall remain the same through the course of that development. The appellant argues that the impact fee is a development standard and therefore the impact fee is not applicable to these developments that receive prior preliminary plat approval. However, the Vested Property Rights Act is triggered if the impact fee is considered a development standard, which the Act specifically references standards and regulations concerning the actual development of the property to include local stormwater requirements, local construction standards of buildings, streets, alleys, curbs, sidewalks, and lot sizes. These are all standards that concern the actual development of property. And in fact, the developer can develop the property without ever having to pay the impact fee because the impact fee is assessed at the time a building permit is issued for a resident. Should the board find that the impact fees development regulation trigger invested property rights, we maintain that the appellants have provided no evidence that it received any prior approvals from the planning department or planning commission for the property at issue prior to the adoption and implementation of the education impact fee. Appellant's second argument is that the impact fees required to be calculated on each subdivision. The proceeds received from that particular subdivision is required to be used on educational capital projects for that specific development. Private Act provides that it is the intent of the Act to grant the county commission, the legislative body, the authority to establish a procedure or system to collect fees from the development on new residential development, so to require that developer to pay his share of the impact on needed educational facilities. Private Act does not require the county to find specific zones to accommodate each subdivision. In fact, the Private Act grants the county's legislative body broad power to implement an impact fee system. To support its decision to have a countywide fee and based on a detailed study supporting the impact and the need for expanded or new education facilities, the legislative body determined that a countywide impact fee is needed because of the ever-changing school districts, as well as the fact development in one area of the county affects schools in another area. For these reasons, Mr. Chairman, we ask for these appeals be denied. I will ask whether there's any representative of the appellants on the line. Hearing none, Mr. Chairman.
You've heard the staff's position on these appeals that he has gone over. Are there any questions, comments? Hearing none, I will entertain a motion to act on these appeals.
Mr. Chairman, this is Josh Hughes. I'll move that we deny the appeals.
Motion's properly made. Do I hear a second?
Mr. Chairman, this is Kenneth Choate. I make a motion to second.
Motion's been properly made and seconded. Are there any comments? Hearing none, we will do a roll call vote on it, and we will begin with Mr. Hughes.
This is Josh Hughes. I vote in favor of the motion to deny.
Mr. Schultz,
This is Kenneth Choate, and I vote for the motion to deny the appeals.
Mr. Lee,
This is John Lee. I vote for the motion to deny the appeals.
Mr. Adams,
This is Glenn Adams, and I vote for the motion to deny the appeal.
this is Ronald Crutcher, and I vote to deny the motion to deny the appeal. Appeal is denied. I'll turn it back to you, Mr. Cook.
Thank you, Mr. Chairman. Next appeals we have from Celebration Homes, and again, without objection, will be heard as a whole. Would like the minutes reflect that no documentation or explanation was submitted by Celebration Homes. They have provided appeal documents that do not provide a basis for their appeals. They provided no supporting documentation or explanation to discuss their appeal. The county maintains that impact fee is not a development regulation or development standard, and therefore vested rights do not attach to these lots. Further, the county maintains that it has adopted the educational impact fee in accordance with the authority granted under Chapter 120 of 1987 Private Acts. There is no requirement the county create a new impact fee rate. For each subdivision, the proceeds raised must be spent in a manner that only benefits that particular subdivision. Finally, the fee was based on a formula related to the impact of new residential development on the need for new or expanded educational facilities. For these reasons, Mr. Chairman, we ask for these appeals be denied. I will ask again whether there's a representative for this appellant on the line. Hearing none, Mr. Chairman.
Thank you, Mr. Cook. You have heard the staff positions on these appeals from Celebration Homes. Are there any questions?
Mr. Chairman, this is Glenn Adams, and I'm going to go ahead and put forth a motion to deny these appeals.
Proper motion. Is there a second?
This is John Lee. I second that motion.
Motion's been made and seconded. Are there any questions? Hearing none, we will vote on it, beginning with Mr. Lee.
This is John Lee, and I vote for the motion to deny the appeal.
Mr. Adams,
This is Glenn Adams, and I vote for the motion to deny the appeals.
Mr. Hughes,
Josh Hughes, I vote for the motion to deny.
Mr. Shaw,
It's Kenneth Cho, and I vote for the motion to deny the appeals.
this is Ronald Crutcher, and I vote to deny the appeal. The motion's been made, seconded, and vote has been taken. The appeal is denied. Mr. Cook, is any other business come before the board?
That is all the appeals we have from you today, Mr. Chairman.
Mr. Horn, do you have any information for us?
A couple of things, Mr. Chairman. First of all, and as was alluded to earlier, this was probably our last virtual meeting. So we will be meeting somewhere in the administrative complex. I strongly suspect we will attempt to meet in the auditorium because that provides us pretty good distancing as far as if we still are in fact doing social distancing and masking. The second part to that is I have looked at the appeals we have collected to date, and it looks as if we do not need a meeting in May, but I would recommend that we consider a meeting on June 10th at 7:30 a.m.
Okay,
Unless we have any objections, I'll make the arrangements and notify you guys as far as when the meeting will occur. And that includes you, of course, Bobby.
I don't hear any objection, Mr. Horn.
I'm concerned about you objecting.
well, I will
So
be a year older on that day, but that's okay. If I have to get a walker out, I'll make it.
We'll get you a cake.
Okay,
So we're setting it for June the 10th. Is that correct?
Yes, sir. Yes, sir.
yeah, at the complex.
Okay.
There's a lot, there's a lot of things that can happen between now and then, and that also buys a little time because it's buys a little time as far as working through the transitions, to how we handle these things. But I don't anticipate any big problems.
Is there any other business to come before the board? Hearing none, I will adjourn this board until the next meeting, which is tentatively set for June the 10th, 7:30, Administrative Complex. All right.
Hey,